Hey everyone, Brandon here from Trucksafe. The FMCSA's DataQs system is the means by which regulated motor carriers and drivers appeal erroneous violations attributed to them during roadside inspections or safety audits. The system has gotten a bad rap over the years, mostly deserved, due to its various shortcomings, but it is a valuable tool that carriers and drivers should be taking advantage of to help improve their safety metrics or PSP records. In this video, I'm going to offer 5 tips for filing successful DataQs appeals. So stay tuned and do us a favor, hit the like and subscribe button below if you find this type of content helpful. So over the years, I've had the opportunity to help carriers and some drivers file hundreds of DataQs appeals. And through that experience, I've learned what works and what doesn't work. So let's run through what I consider the 5 best ways to improve your chances of success on DataQs appeals. First up, choose your DataQs battles wisely. There are essentially 3 types of DataQs users. First up are those taking the blanket approach and challenging every violation that's attributed to them through roadside inspections, whether those appeals are justified or not. Next up are those that utilize the DataQs system but only to challenge clearly erroneous violations. And then there are those that don't use the system at all. Now, I've typically recommended that carriers and drivers adopt the approach that falls somewhere in between the first and second groups. I've never been a proponent of the blanket approach, as I think it cripples the credibility and lessens the chances that you will prevail in a justifiable appeal. Plus, it's really just a waste of time and resources to appeal violations against which you have no real defense. That time would, in my opinion, be much better spent working to address the issues that led to the violations in the first place so that they don't reoccur. With that said, I also tend to think that most carriers and drivers could be a little more aggressive in their approach to DataQs. What I mean is that rather than just filing DataQs in cases where the officer or investigator was clearly wrong, I recommend utilizing the system even in more questionable cases. There's really no downside to doing so, and if you're able to present a compelling case, then you only stand to benefit. Ultimately, I recommend that carriers and drivers use good discretion in deciding which violations to appeal. Factors to consider include how long ago was the violation assessed. The more recent the violation, the better your chance of success. Did the officer or investigator make a legal or factual error? Legal errors are easier to establish, assuming the regulations support your argument. Factual errors are tougher to address unless you have concrete evidence that the officer was wrong. And lastly, be sure to consider the amount and quality of evidence that you have to support your argument. In my experience, if it's just your word against the officers, your chances of prevailing are virtually nil. All right, the next tip is to try and file your DataQs appeal within 30 days of the subject inspection or audit. Now, although the FMCSA's regulations technically allow up to 3 years to challenge roadside inspection violations and 5 years to challenge crashes through the DataQs system, your chances of succeeding on the DataQs appeals are much better in my experience if the appeal is filed within the first 30 days. Obviously, memories fade over time, as does any evidence that you may have to support your appeal. So, the sooner that you file the appeal after the subject inspection or audit, the more likely it is that you will have access to what you need to prevail on your arguments. Also, keep in mind that DataQs, even though they are filed through an FMCSA system, are forwarded to and reviewed by the state agency that issued the violations in the first place. For example, if the violations you are challenging was assessed by the Indiana State Police, the DataQs appeal that you file will be forwarded and ruled on by the Indiana State Police. And in my experience, the person reviewing your appeal will almost always consult with the officer that issued the violation before ruling on your appeal. If you wait for more than a month to file your appeal, it's likely the officer won't recall the inspection and more likely that he or she will just stick to their guns. All right, number 3, understand and choose the correct type of request for your data review. DataQ users can submit various requests for data review, RDR types, within the system. Choosing the right RDR for your situation is crucial to succeeding with your appeal. There are dozens of RDR types to choose from, including some dedicated to obtaining missing inspection reports, for example. But the most common RDR types are the following. First up is the incorrect violation RDR, which is used to challenge erroneous violations attributed to you during a roadside inspection. This is far and away the most common RDR type. Other common types are the citation RDR, which is appropriate if you have successfully appealed a state citation that was connected to your roadside violation. In other words, if you receive a ticket for a violation discovered during an inspection, and then you successfully defend that ticket in state court, you can then file a subsequent citation DataQs RDR to get that violation removed from your US DOT profile. All right, and last but not least is the crash preventability RDR, which is used to argue that a crash was not preventable on your or your driver's part. This RDR type places your appeal into the FMCSA's crash preventability demonstration program, which is the subject for another video. So once you've selected the right RDR type, another tip is to attach as much evidence as you possibly can to support your case. Of all the tips we'll discuss in this video, this one likely has the greatest influence on your chances of success. If you're challenging a violation assessed during a roadside inspection or audit, you must submit evidence to support your argument, even if that evidence is just a signed statement from you or your driver, for example. Put differently, if your appeal amounts to nothing more than your word against the officers or the investigators, there's a 99% chance that it will be denied. That's why it's crucial that you upload supporting evidence with your appeal. But what exactly makes for good evidence? Really, it's anything that lends support to your version of the facts or the law. For example, let's say you were assessed a violation for failing to maintain your lane on a highway. If your vehicle was equipped with a video event recorder that captured the moments leading up to the roadside inspection, then I'd want to upload a copy of that video to establish that you did in fact maintain your lane, if that's the case. Another example, if in the context of a safety audit, you're assessed a violation for failing to conduct a post-accident drug or alcohol test on an accident that didn't necessitate such a test, you may want to upload a copy of the accident report to demonstrate that the accident was not of the variety that requires post-accident testing. The tougher prospect is a situation where you have no physical or documentary evidence to support your position. For example, let's say you're assessed a violation for failing to have your ELD instruction manual in the cab during the inspection. Now, unless your vehicle is equipped with an inward-facing camera that captured video of you or your driver presenting that manual to the officer during the inspection, you likely don't have any evidence to conclusively prove that the manual was, in fact, in the cab during that inspection. In that case, it's going to be your driver's word against the officers, and it's going to be tough to prevail. Regardless, if you are intent on appealing it, I would recommend that at the very least, you have your driver sign a statement indicating that he or she did, in fact, have the manual and made it available to the officer during the inspection. Suffice it to say, the more evidence you have to back your appeal, the better your chance of prevailing. Okay, last but not least, be sure to respond promptly to any follow-up requests through the DataQs system. Occasionally, the individual reviewing your DataQs appeal may have follow-up questions or requests for additional information. If so, they're going to ask questions or request the information through the DataQs system, which will then generate an email with that request to the person who filed the appeal. It's important that you respond to any such request by logging back into the DataQs system and submitting a response. The FMCSA instructs those who are tasked with reviewing DataQs appeals to close out appeals if the reviewer sends a follow-up request and does not receive a response from you within 14 days. With that said, the FMCSA notes that appeals can be reopened if you subsequently produce the requested information or answer the follow-up questions, but it's better to respond within that initial 14-day time period. All right, that's going to wrap things up for this video. DataQs appeals are one of the few ways that motor carriers and drivers can improve their CSA scores and PSP profiles, so it's important that you take advantage of that system when possible. However, filing appeals well after the inspection dates or without any supporting evidence is almost certainly a waste of time. So be sure to plan out your appeal and try to follow the tips we discussed in this video. For even more in-depth information about these types of regulatory topics, be sure to check out our innovative online compliance courses for safety managers and drivers over at trucksafeacademy.com. Also, be sure to check out our detailed compliance articles on our website at trucksafe.com and follow us on our various social media pages for the latest highway transportation news and analysis. Thanks for watching.